Bradley Moss, who joins us. So, yeah, as we expect, I don't think we expected any of these trials to come before the election anyway, but this assures us that we're going back. But your reaction to what was, technically a split decision, but did any of it surprise you?
A little bit, only in the sense of this presumption of immunity that the court afforded to former presidents if it's even in the outer perimeter of their authority. So to sort of clarify the nuance of the ruling, there was one batch of types of authority, what are called core authorities, things that are exclusively within the authority of a executive branch officer, namely the president. That's absolutely immune. That's, for example, in that election interference case, that's Trump's coordination with DOJ officials like Jeffrey Clark trying to interfere in how the states were going to proceed forward in putting forward electors. Then there's the issue of, okay, if it's not a core executive authority, but it's still within the outer perimeter of the executive branch's power, is it an official act, and can that immunity be rebutted? And what the courts, what the majority opinions ruling really did was hamstring the prosecution's ability to prove, to overrule that presumptive immunity, because it excluded all kinds of information and evidence that otherwise they were going to rely on, namely information that would otherwise have been immunized if brought up in the context of charges. So going forward, it's easy to see how more or less the way this ruling will be implemented is we effectively turn presidents into, quote unquote, constitutional monarchs,
right,
absent proof to the contrary.
That's what Justice Sotomayor was getting at. If we can fast forward our elements, guys, to the Sotomayor dissent to follow up on what Bradley's talking about. Orders the Navy SEAL Team 6 to assassinate a political rival. All right, you're immune. Organizes a military coup to hold on to power. Immune. Takes a bribe in exchange for a pardon. Immune, 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 immune. And every use of official power, the president's now a king above the law. So it sounds like you think there's something to that, this use of that analogy, saying, yeah, they just made the president into a king. Is it, you don't think she went too far?
No, I think that was pretty much spot on. And even if it's not absolute immunity, even that presumptive immunity, you have to think about this. Someone who could order those actions would then have to voluntarily agree to surrender the powers of the presidency at the end of his or her term, and then possibly be subject to criminal prosecution, because you can't indict a sitting president. So this is someone who may have ordered the assassination of a political rival, or may have sold pardons for personal money, and then left office and would then somehow have to be subject to criminal prosecution, relying on evidence that can be even admitted. It couldn't be information that came from those core executive authorities or powers, such as communicating with the Justice Department or communicating with military leaders or the heads of the intelligence community. Those would all be excluded from evidence. So you could easily see how so we say ethically deficient president could easily use this ruling to exploit the outer reaches of authority to immunize themselves from any kinds of criminal conduct.
What about President Trump or former President Trump and what he's already done, what he's already been charged with, and how it affects Jack Smith and his prosecution? Go back now to the SCOTUS ruling here on remand. The district court must carefully analyze the indictment's remaining allegations to determine whether they involve conduct for which a president must be immune from prosecution. Testimony or private records of the president or his advisors probing such conduct may not be admitted to evidence at trial. So what are we going to see next here from the district court in that Trump January 6th case?
Yeah, so it's going to go back to Judge Chutkan, and it's going to be a question for Jack Smith and his team of how many of the original charges that remain in place do they want to still proceed forward with, because now they're going to have to go into an evidentiary hearing. And now they're going to have to demonstrate, one, that the idea that these aren't official acts, it's beyond the outer perimeter. Or two, if they are at least official acts, that the immunity has been rebutted, that it would not intrude upon executive authorities to permit a criminal charge to be brought.
What's your best guess on what comes out of that?
That even no matter what Judge Chutkan rules, any of it's going to be appealed.
Right.
It's going to automatically get tied up in appeals to the D.C. Circuit and ultimately the Supreme Court, because they're all tied up in immunity. That delays us easily for months on end.
Yes. Thanks so much for watching. Just go to joinnn.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.